Aloha mai kako. Welcome to the closing plenary for this year's NLADA conference, Redefining Justice. As I was fortunate enough to welcome you all on Tuesday to the virtual conference, I again want to look to closing by acknowledging that I'm able to be here with you from the land of my people, the Kanaka Maoli. I'm coming to you from the Mokopuni of Oahu, Moku of Ko'olaupoko, Ahupua'a of Waimanalo, and Ili of Mauna Lua. For those of you that were able to join us then, I hope you were able to take a moment this week to listen to and hear the sounds and the rhythms of the communities that you serve as the inspiration for the diversity from which we are all here today as we look to redefine justice. This morning or afternoon, depending on where you're located, we are fortunate to have with us Ambassador Jonadev Chahudi of the Muskogee Creek Nation. We are so grateful to Stephanie Hudson, Executive Director of Oklahoma Indian Legal Services, who helped make the connection so that he's able to speak with us today. Ambassador Chahudi serves as the ambassador of the Muskogee Creek Nation that was created under the laws of MCN in 2019. The creation of the ambassador position renewed a long tradition held by the Muskogee Nation, as well as tribal nations throughout the continent, of utilizing emissaries and diplomats to engage with other sovereigns on government-to-government basis. In this role, he works with Congress and other federal officials, as well as representatives of tribal nations, states, and other governments to advocate for and advance the interests of the Muskogee Nation, of which he is a member. He also served as the chairman of the National Indian Gaming Commission from 2013 to 2019, as senior counselor to the Assistant Secretary Indian Affairs at the U.S. Department of the Interior. He has practiced in federal, state, tribal courts across the country, and he has served as a judge in 5 tribal nations, including as Chief Justice of the Muskogee Creek Nation, the highest court of the 4th largest tribe in the nation. His professional background also includes serving as a community organizer, adjunct professor, and author. But most importantly, he's also been a public defender and legal services attorney. He received his law degree from Cornell and his undergraduate degree from Dartmouth. When I saw that he had graduated from Dartmouth, I have to admit to doing a little bit of Googling. And lo and behold, I found him speaking at the Brookings Institute a few years ago and being introduced by my high school classmate, Randy Aki, who was a David Rubenside Fellow at the time. He called him a nerd from their Dartmouth days. And while I knew Randy through honors classes and theater, seeing that interaction reinforced how small our world really is becoming. Last year, after the McGirt decision, he wrote a powerful op-ed that spoke to the presence of insurmountable loss to the Muskogee people and the vindication in the ruling of the confirmation of the treaty. In it, he wrote, "For my mamagi and my mom, home has always been a place of systematic erasure, but they never gave up. Mom always took me to visit the land in our south of Tulsa that contained the burned remnants of her childhood home and her buried umbilical cord, a connection to our land that no federal law or policy could ever dismantle. Like the generations before them, Mamagi and my mom persevered with the steadfast hope that their children or their grandchildren would someday be recognized as Muskogee in their home. For me and for thousands of other Muskogees, the court ruling is more than a legal confirmation of a treaty. It is confirmation that the sacrifices of my mom, my Mamagi, and all of our ancestors were not in vain, that my children won't be erased in their own home, that we are still here." Please welcome Ambassador Chahudi.
Thank you so very much, Nalani. I'm deeply, I'm honored by that introduction and touched that you actually looked into that Brookings connection with Professor Aki. He is a nerd, but a very cool nerd who has Indian country, but also the global future at his heart and all the work that he does. And thank you for that incredible introduction. Let me just first start by saying Hasagan Masi, Bafanga, Amalgap, Bokmitas, XG, John Dev Chowdhury, Jifkados. My name is John Dev Chowdhury. May Creator honor us all with blessings today, and let us be of one mind and one spirit. It's a deep, deep honor to be invited by NLADA today, and I very much appreciate Stephanie Hudson reaching out. Before I begin my comments generally, I do want to say how much of a personal honor it is. I consider myself a defender at heart and a legal aid attorney at heart. I was very fortunate to work in both arenas at different stages in my career. I helped direct the Salt River Pima Maricopa Indian Community's legal aid office years ago, and I served as a deputy defender in the Maricopa County Maricopa County system years ago. I also clerked for the Federal Defender's Office. So I very much appreciate the incredibly important work that defenders and legal aid attorneys do to not just serve individual clients, but uphold the integrity of our Constitution and, frankly, the integrity of our democracy. So it's a deep, deep personal honor to be here with you. I am here in my capacity as ambassador for Muskogee Creek Nation, and I do want to talk to you a little bit about my nation and how our efforts to preserve our sovereignty, protect our future, and ensure that we will never again be erased in our own homes are inextricably interwoven with the important work that your organization does. So who are we? Muskogee Creek Nation is one of the foundational tribal nations within the United States. We're originally located in the southeastern part of the modern day US. We're from Georgia and Alabama and northern Florida and even parts as far west as Tennessee. We were among the first tribal nations to engage in full-scale diplomacy with European powers in the 1500s and the 1600s, long before the formation of the United States. So some of our earliest interactions with European nations were with the Spanish and the French, and later on, England. And all of that helped shape our nation's structure, our government, but those interactions also shaped the structure and the structure of the United States government as well. It was a two-way street. So some facts about us that a lot of folks don't know. We were actually among the first tribal nations to enter into treaties with the United States. Shortly after the Revolutionary War, and after ratification of the modern day US Constitution, the United States was dearly in need of credibility on the international stage. They needed to show that in addition to simply winning the Revolutionary War, they were a true government with all appropriate attributes of international sovereignty. And what's an important way to show that? An important way to show that is engaging in government-to-government relations with other recognized sovereign nations. Now, our nation, as I mentioned before, had a long-standing history of entering into agreements and actual treaties with European powers. We were among the first tribal nations to step up and help provide the United States with that credibility on the international stage. The US Constitution, as we know it, was ratified in 1789. The Treaty of New York between the Muskogee Creek Nation and the United States was ratified in 1790. That treaty was actually negotiated in George Washington's house, and it helped delineate the southeastern boundaries of the United States. With it, there was a concession of significant amounts of tribal lands in Georgia and Alabama in exchange for assurances of protection and assurances of sovereignty that were embedded in that treaty. That was one of many treaties entered into between Muskogee Creek Nation and the US, all of which, to various degrees, were not fully honored by the United States. And nonetheless, it was an important treaty in the history of the United States, and it's something that we point out on a regular basis so people understand that the The existence of tribal nations were critical to the foundations of the United States, and you can't tell the story of America without telling the story of tribal sovereignty and tribal government-to-government relations. So I'm very proud to serve as the first ambassador of our nation since the return to this history of diplomatic engagement that we've seen. As was mentioned, my position was created in 2019 by law, but it was not, and in its creation, it was explicitly designed. The position was explicitly designed to return to our history of nation-to-nation engagement with the United States and other nations. But I may be the first ambassador under this law, but I'm by no means the first ambassador or emissary of the Muskogee Creek Nation. Although the actual position fell off the map for about 80 or 90 years after many of our abilities to function as a sovereign nation were decimated by federal actions, prior to that, we had ambassadors who engaged with Congress to fight against the destruction of our reservation, fight against removal. We had diplomats and emissaries who would regularly travel to Washington, D.C. to advocate for our nation's interests. And again, before the formation of the United States, we had delegations who would travel to London and other parts of Europe to, again, engage in diplomatic relations. Those are the historic roots of the position. And those roots underpin the importance of establishment of this position. And I'm proud to say that since we created this position, other nations have started to follow suit in the development of whether they're embassies or ambassadorships. Now, there have been other tribes who have had government affairs offices. There have actually even been other tribes that have had an ambassadorship, but ours was the first to be created in many, many years. And it is consistent with our overall commitment to working to strengthen our sovereignty, to protect not only our citizens' futures, but the futures of everybody within our borders. And that brings me to the part of the conversation that I really want to focus in on, and that's the tie-in between your important mission and the work we do at Muskogee Creek Nation. As I said before, Creek Nation strongly believes in engagement with the United States on a nation-to-nation basis. That said, it hasn't been easy to protect our sovereignty, and it's even been harder to protect our land base, our reservation boundaries. In that op-ed that was read, I wrote that a little over a year ago in the wake of the historic Oklahoma versus McGirt decision before the U.S. Supreme Court. And in that decision, the U.S. Supreme Court was in a position to determine whether or not our reservation remained in full force and effect. So a little bit of history, even though we were in the southeastern part of the United States, in the 1830s, we were removed to Indian territory on what is known as the Trail of Tears. And we were placed within Indian territory on the Muskogee Creek Nation Reservation, which in modern times covers various parts of 11 counties. There were a number of treaties that led to our removal, and then further eroded our land base. But the most recent treaty, and the most critical one, that contained the last metes and bounds of the boundaries of our reservation, was our Treaty of 1866. And the U.S. Supreme Court had before it a question of whether or not various acts by Congress, the creation of statehood for the state of Oklahoma, the allotment policies of the early 1900s, late 1800s, early 1900s, whether or not these acts of Congress amounted to disestablishment of our reservation boundaries. The state of Oklahoma certainly thought they did, and they argued strongly against our sovereign boundaries being respected and argued that not only had the force of history somehow dissolved our boundaries, but to find otherwise would result in chaos and criminals running the street. And they put forward a number of sky is falling narratives to support their position. But other organizations also tried to argue against preservation of our reservation boundaries, including various agricultural and oil and gas interests. They all filed briefs with the United States Supreme Court. But fortunately, the US Supreme Court, in a 5-4 decision penned by Justice Gorsuch, eloquently, analyzed or went through the whole history of our nation and found that Congress had never explicitly disestablished our reservation boundaries, and found that because it had not done so, the Supreme Court would hold the United States to its word. And so, in other words, the Supreme Court was effectively saying, while Congress may have the power to destroy or disestablish a reservation, and when it does so, it has to do so explicitly, and it has to show its face to the world. It can't do so by implication. There's a huge watershed case resulting in affirmation of our reservation boundaries, but significant clarity to the legal jurisdictional issues in place after the decision. While there are certainly many practical adjustments that have to occur to take advantage of that clarity, the laws that apply to reservation lands are subject to common law, primarily federal common law, that has been teased out in the federal courts for many years for other reservations throughout the country. So there, while many people claim that the McGirt decision would have resulted in chaos, and what really happened, if people will take the time to avoid rhetoric and just look at the law, is that the body of law that applies to our reservation has now been clearly stated, and that law is what law applies to tribal reservations. And if you have a specific question about a specific case, you need look no further than existing federal law to determine, what happens on a reservation. Once our reservation was affirmed, that's where we're at. But none of this would have happened without defenders, without advocates who are have the same mission as the NLADA. So I talk about how we argued this and the court ruled on that. As many of you know, the case actually arose because of a criminal prosecution, originally a state prosecution in a related case, the Murphy case, and the original attorneys, the original law office that argued that our reservation had not been disestablished was the Federal Defender's Office. I was honored a few years ago to be on a panel with Patty Palmer Gazy, who I believe she was at the Western District Public Federal Defender's Office. And she talked about how important the argument was, this argument about the status of our reservation was to defendants' due process rights. And so she was involved in both the Murphy and McGirt cases. Those cases bubbled their way up to the US Supreme Court. Actually, Murphy was heard first, but because Justice Gorsuch was recused, that case wasn't decided. I mean, case was deadlocked 4-4. Justice Gorsuch wasn't recused in the McGirt case, and that case came out 5-4. And so it was the federal defenders that brought the original claims that led to this watershed case. And our nation, as basically was a real party in interest. We certainly submitted briefs in the case, but there were also other amicus briefs that were submitted on behalf of various federal prosecutors. There was a U.S. attorney's brief that was submitted, as well as various Indian country organizations. So in a real sense, the Federal Defender's Office are a significant hero in bringing these important questions of legal boundaries to light. Now, a lot of the same people who would have the public focus on the rhetoric leading up to the case tried to bring public attention to the underlying crimes involved in the case, and to be sure those crimes were horrific. But focusing simply on the crimes and not understanding the constitutional issues at hand, the pre-constitutional issues at hand, and the due process issues at hand, kind of missed much of the point. And much of the point was, we live in a democratic society governed by a constitution. If there's going to be any sense of fairness, that constitution needs to be respected. And so those of us in the Indian law advocacy community, and certainly those of us in the Muskogee Creek Nation who understood the importance of the McGirt decision, very much applauded the Public Defender's Office, their role in making their arguments they made regarding our reservation boundaries. And that brings me to kind of another reason why I'm so honored to be here today. One of the commonalities in working both with the defenders communities and the tribal sovereignty community that I've seen is that, by and large, practitioners in these communities truly believe in their respective missions. The mission of defenders is, of course, in addition to zealously serving the interests of individual clients, broader than that, the larger mission is to protect constitutional protections that keep everybody safe, protect constitutional protections that strengthen democracy. Similarly, those who advocate for tribal sovereignty believe in upholding the very fabric of the American democracy, recognizing the role that nations such as the Creek Nation played in ensuring survival of the United States when the United States needed legitimacy on a world stage the most. These are commonalities among communities that require both communities to serve an interest that is greater than any given case at hand. And for that reason, I just wish everybody the best today. It's an honor to be before you. We've got a couple minutes left, and so I want to kind of close with one little story from my time as serving as a clerk in a federal defender's office. And I could take quite a bit of time to tell this story, but the short version of it is, I was honored to work with a team that was representing a Native defendant for a triple homicide for the vehicular manslaughter case. For basically the U.S. Attorney's Office claimed a person was intoxicated and killed his friends as a result of a single car accident. Once we started to look into the case, the potential for a product liability defect was clear. There were many witnesses who had noted that there were mechanical problems coming from the car. There were anomalies in the crash scene. Well, we never fully got a chance to investigate the car because it had been destroyed before the defense fully got to investigate it. So we had a strong case for dismissal for destruction of potentially exculpatory evidence. But ultimately, it's a defendant's choice as to whether or not to accept a plea deal, and a plea deal had been offered. And despite the strength of this potential claim, this Native defendant said something that I'll never forget. He said to me that, regardless of what happened, my friends passed away in that accident. And I don't think I had anything to do with it, but I survived and they didn't. And I need to do my part to honor their lives. And so he was insistent on taking the deal. And despite everything that could have been argued in the courts, and discussions were had with him, his family, and the decision was made to plead out that case. I'll never know what would have happened had the case gone to trial. There are inherent risks with any trial. But that cultural component of having responsibility to one's community and to one's friends, despite the actual legal culpability involved, was something I understood very well being Muskogee Creek. You have kinship and cultural responsibilities to your community that go beyond mechanical applications of the law. I understood that deeply, and I know good attorneys who seek to find the best outcomes for their clients really seek to learn about them as full people. And when we're dealing with Native clients, understanding the cultural considerations that go into not just plea decisions, but where folks find themselves at different stages of their lives that result in them interacting with the justice system is critical to meaningful defense of clients, but it's also critical to serving the larger mission that you all have in upholding the integrity of the Constitution and upholding rights that protect us all. So with that, I think we're at the time, the scheduled time for closing. But hopefully I've given a little background about my nation, our role in trying to advocate for sovereignty in a way that I believe strengthens the structure of the United States, and how similar that mission is to the role of the various members of the NLADA. And I honor you in the work that you do, and I honor your mission. And from the bottom of my heart, Mado, for this opportunity to appear before you all today. Mado.
Thank you so much, Ambassador. We're just so honored to be able to feature you, and really, as you mentioned, the work serving tribal communities, the work that people do in this community to serve others really is unrivaled. And it actually is a unique part of our community, as you mentioned, the organizations, the advocates who really are advocating for tribal communities in a way that is appropriate. So thank you for sharing your story with us. Thank you for sharing your thoughts with us. And thank all of you, our attendees, for joining us this week. As you know, we were hosting 3 conferences this week: our farm worker conference, our in-person conference, and our virtual conference. The support we've received from you, we really could not have anticipated. We had more than 1,000 of your advocates, your civil legal aid advocates, your client advocates, your public defense advocates join us this week. And your support in terms of the level of participation, both as panelists and attendees, really could not have been anticipated. And thank you for joining us. Thank you for engaging with us. And know that we are here to support you. That is true during these conferences, and it's true throughout the year. Over the course of the week, you've heard about NLADA's Racial Equity Initiative, launched officially last week. That initiative arises from a task force of NLADA's board of directors comprised of representatives from each of the pillars of the NLADA community: civil legal aid, client advocates, and public defenders. And it's just one example of the strength our communities have when we come together. And it's one example of our commitment to listening and elevating your calls for us to act, and how, when we can act together, we can be powerful and impactful. Throughout the week, you've come together to support each other, you've come together to learn from each other, and you've come together to raise the bar together across the country. Thank you for always working to do that, and thank you for allowing us to be part of that work. We're not done. We do have one final session for you today, our traditional historical hot topics in civil legal aid, which will open up immediately after this closing session. So please do join us for that. And then one final reminder that session evaluations, session materials, including the recordings of our sessions throughout the week, will be posted in the Dropbox. Also, you will find there the information to apply for CLE, and those codes, as you know, have been posted throughout the chats throughout the week in all of your sessions. As always, please let us at NLADA know what we can do to support you across the country. We do look forward to continuing to engage with you every day as you take on the work that you do. on behalf of NLADA, thank you for joining us this week.